Bună ziua și bine v-am regăsit la ora arbitrajului. Deși am anunțat la ultima ediție că intrăm în vacanță judecătorească, o fericită circumstanță excepțională m-a determinat să organizez și o ediție de vară, ca să o numesc așa. În perioada 21-22 iunie, în România au existat mai multe evenimente organizate de către Curtea de Arbitraj Internațional ICC Paris și de către Comitetul Național ICC România, în colaborare cu Curtea de Arbitraj Comercial Internațional de pe lângă Camera de Comerț și Industrie a României. Nu puteam să nu folosesc această oportunitate sau să o ratez și să nu avem un eveniment cu doi reprezentanți importanți ai ICC Paris, astfel că avem pe parcursul acestei veri o ediție excepțională. Este excepțională și din perspectiva limbii, pentru că, evident, dată fiind naționalitatea invitațiilor mei de astăzi, vom avea o primă ediție a orei arbitrajului în limba engleză. So, for the previously explained reasons, we are going to switch to English, and I will introduce my guests today. The first one is Maria Hauser-Morel, Counsel with ICC Secretariat in charge with the cases from Central and Eastern Europe. Maria, welcome.
Thank you very much. Welcome.
And
sorry for not being able to do it in Romanian, but...
No, I think it's better. Isn't English the official language of international arbitration?
Yes.
Yes, exactly. Our second guest is Leticia de Montalivet, which is a director for arbitration and alternative dispute resolution in charge with Europe Zone within the same International Court of Arbitration, ICC. Welcome, Leticia.
Thank you for inviting us.
Is your first visit in Bucharest?
It is our first visit, yes, in Bucharest. And it has been warm both in terms of temperature and the greetings that we received and the contacts that we were able to make here.
As I have just returned from Paris, and Paris was warmer than Bucharest, is Bucharest cool?
Bucharest is European. That's, I think, what we can...
Okay. Can you briefly explain the purpose of your visit in Bucharest? It was a professional visit, obviously not for tourism, but I hope you will come back also as a tourist in Bucharest.
Absolutely. It was the first time that we came as a delegation in Bucharest. I guess it was a long time that we were thinking about it, but the case management team usually are totally focused on the case management, and so we couldn't find the time and the energy to do it. And so when Alexis Moore, our chairman, arrived, he really wanted to have a focus on the users, and that's why he created my position as a director for Europe. And I started last September. I was at the ICC before, but I started in this position last September. And one of the first projects we started to think of was to come in Bucharest, in Romania, to meet the users and the practitioner from Romania. Actually, Romania is a very important country in ICC, at the ICC court, and not only in terms of a number of parties involved, but also in terms of the place of arbitration. Bucharest is on the top 10 of the place of arbitration chosen in our case worldwide, so it's significant. And also the Romanian law is often chosen as the substantive law in cases. So for all these reasons, we thought that it was really important that we came. Actually we came to meet and to listen to people. So it's the message we wanted to convey, that we're available for people, and we were very glad of all the meeting we had here, thanks to the National Committee, ICC Romania.
And it was also an occasion to present the new tools that we have available, in particular the expedited provisions, and it was a very successful session. People were extremely interactive. People had many questions, observations that showed that there is a very good understanding of this alternative dispute resolution in Romania, and the will to have more, to know more. And we have to add that in addition to Leticia and myself, there was also for 2 days with us Alina Leovanu, who is known to many Romanian practitioners. She's Romanian and she used to work in my team for many years as deputy counsel, and Alina is now in charge of the ADR department, so department dealing with mediation, expertise, and other services. And so Alina was also present in all these meetings.
Yes, staying to Alina, I can publicly announce that I managed to obtain her firm promise that she is going to be my guest with the occasion of her next visit in Romania. Unfortunately, she needed to return in Paris while we record the show today, and she was unable to make it. Let's come back to the events organized here in Romania, and can you please provide more details? There were several events, not one, a conference, a round table, and I'm not sure whether there were some extra events. Please provide some details as to their content and your feedback afterwards.
Mm-hmm. The conference concentrated on one topic that appeared important to us from the user's perspective: independence and impartiality of arbitrators. And so during this conference we concentrated on two aspects of independence and impartiality. Institutional aspect: what is the role of the institution in maintaining independence and impartiality? And secondly, what are the best practices in terms of independence and impartiality? And we have, it was a very interesting debate during which panelists recognized that there may be some cultural differences, specificities in each country with respect to the standards of independence, but that the role of the institution is to make sure that the internationally recognized standards are respected. So there was quite interesting debate as to how to reconcile the two and make sure that the users have a good understanding of this. We also had a session during the conference, a separate session co-moderated by Crenguța Leoaua, the Vice President of the Court, and myself, on the expedited rules, which had a very interactive model of a mock session. So we, rather than making a long presentation about the new rules, we actually took a scenario that we were trying to solve applying the new rules with the participants. So that was it. But we also had the round table with in-house counsel, which had no fixed format, no PowerPoint presentation. It was a very open discussion with in-house counsel on the problems and issues and questions that they may have in respect to both ADR, expertise, mediation, and other forms, and arbitration. So the goal was to really, and they asked very open questions that were sometimes linked to the fact that they didn't understand certain issues. So there was an opportunity to clarify things. And also we had less formal meetings directly with some users of ICC, but these were just directly at the companies.
How do you find, how can you feel the users, the ICC users that you met directly and answered their questions on one hand, and on the other hand, in terms, I suppose you can make a comparison to other jurisdictions. Are they knowledgeable? Are they interested? How keen are they to understand more and in depth ICC rules and their ICC practice?
In my capacity as counsel in team dealing with cases from Central and Eastern Europe, I indeed quite often travel in Central and Eastern Europe and talk to people, and I always find the direct contact with the users more interesting than formal conferences. There is definitely big interest in Romania for arbitration. This is also due to the large use of arbitration for big construction projects and privatization projects. So people were used to it. I think that there are still some questions, valid questions, and issues that need to be well understood. But I think in general, there is some sort of general understanding and enthusiastic and general approach to arbitration. And one of the points that many of the users recognized in terms of ICC arbitration is the two main points, I would say, is the maintaining of very strict standards in terms of independence and impartiality and the control exercised by the court, and users recognize this control. And also the control exercised by the ICC, the verification of draft awards, and users recognize that the quality of awards, ICC awards, is very good because of the verification exercised by the ICC. So the comments that we receive show that there is understanding of arbitration, and more specifically of ICC arbitration.
We move a little bit to another issue, and then we are going to come back to our arbitration topics. Laetitia, your portfolio includes not only arbitration but also alternative dispute resolution, the other mechanism. I am sure you are aware, in Romania, unfortunately, except for having arbitration in an appropriate place as development, usage, openness to arbitration, the other alternative dispute resolution mechanisms are in an, let's say, too underdeveloped stage. People do not use as much as they should and they could other alternative dispute resolution mechanisms. What do you believe about this, if you can have a view concerning this situation? And the second question is whether ICC has any other concrete plans to help Romania to improve the usage of alternative dispute resolution mechanisms other than arbitration.
It's a very interesting question, and actually mediation was part of the discussion, especially. We spoke a little bit about expertise and almost none about dispute board, I have to say. But mediation expertise were two issues raised into our discussion, especially when we mentioned the regulatory area, so where there is a law that deal with this issue, and even we feel that is not as developed as the arbitration, we feel a great interest in that, and I was glad that Alina could join us. So I guess when we'll be back in Paris, we will discuss that with her and maybe set up a plan to go further, because there are definitely an area to develop.
The paradox is the following, and we are going to move to another topic. The paradox is the following: mediation has raised as a public topic in some moments more interest than even arbitration, but purely from a theoretical point of view. As far as the practice is concerned, mediation is far away of what it can and it should be in Romania. And there are some explanations that me as a Romanian practitioner I can have, but on the other hand I still fail to understand why is this.
I think it's just a question of also explaining to the users, and I see the same problem occurred several years ago in Poland, and slowly but surely the Polish users are starting to think more about mediations, and there are indeed some mediations already in Poland, but it has not come from one day, in one day. It was a long process of explaining, and I think if we come and for a long time explain what mediation is, how it works, what are the possible options, then the users, the business users will have more confidence in this process. But I think it cannot be just, we cannot sell it on the market one day and hope that the next day we will be the first on it.
We have mediation also in Romania. It's not known as if it does not exist. But again, not to the level that it should be. And I'm sure that ICC umbrella or label can help mediation in Romania.
For sure.
Because it adds something to an instrument, an institution that can help parties to reach an agreement and avoid going to court or to arbitration to settle that dispute.
But I would say that in mediation you have a cultural aspect that you feel less in arbitration.
Yes.
So it's also about the national context. So, but definitely I'm sure there is things to be done, and we're lucky enough to have a Romanian in charge of the ADR issues in the headquarters. So I'm sure that Romanian will be one of our key.
Okay.
Maybe the next generation as well that may be watching us is more, will be able to move forward.
Okay,
So
let's get back to arbitration. I have heard many times from my clients, and not only, questions or concerns as to how can I deal with an arbitration before ICC. They have that English website, they have the scale with the taxes. I don't know how much I'm going to pay. I don't know what am I supposed to do. I don't have money for a lawyer or not now. I would like to to file the request for arbitration without a lawyer. And my question is for all those people hopefully watching us, what is the answer to their concerns? How can they handle, without the support of a lawyer, the initial stage of an ICC arbitration?
It happens actually quite frequently in our region, especially. I see many cases being filed directly by the companies. And sometimes even these companies remain unrepresented throughout arbitration. It happens for smaller disputes which don't necessarily require so sophisticated representation. First comment, in doubt, call us. We are always available prior even to the filing of the requests for arbitration. I receive many calls, and we can obviously clarify how the procedures function. So the party which is not represented may file the request. In terms of costs and all the information about ICC arbitration, ICC website has recently been largely improved and is much more user-friendly now, we wish to hope. We will make sure, one of the things that we are going to do is to make sure that there is a Romanian version of the rules that will be available on the website. So we will definitely, that's on our priority list for the next month, to sort of make it easier for Romanian users to use it.
Sorry for intervening. That is going to be very helpful, because there are numerous cases with the official language of the arbitration Romanian, and then an official tool issued by ICC and not approximate translation is very useful.
Precisely. No, we fully agree, and so we recognize it absolutely the need to do this. In terms of costs, there are very clear tables of minimum and maximum costs as fees in the rules. But the easiest way to find out how much you would have to pay to the ICC to cover the cost of arbitrators in ICC is to go to our website, and there is a calculator of costs. And you just put in the amount in dispute, convert it into dollars, if it's in Romanian lei or in euros, convert it into dollars, and you will have just the average fees and the administrative expenses which correspond to the amount in dispute. And so this amount will usually stay that will be the advance on costs which will have to be paid by both parties. And it will usually correspond to the final costs of arbitration fixed by the court. Now, of course, you know, Cosmin, that these costs do not include costs of representation. It is not for the institution to cap the lawyer's fees. So, of course...
Fortunately.
So if a party is not represented, obviously the party will not have the cost of the lawyer, but it will have to foresee some money for the ICC advance. Now, there are, of course, tools in the rules, such as if a party has difficulties paying everything at once, it can ask possibility to pay in installments, so that we remain flexible for parties that have good reasons and need a little bit more time to pay.
So, I think the most important part of your very detailed and interesting answer is that the Secretariat is not there only to support the case and the arbitrators. It is there to answer any potential questions the parties or the users may have.
Absolutely.
Which is maybe unusual for Romanian parties to understand that an authority, the court is an institution, is there to act in a proactive manner, to answer the phone, to reply to emails, and provide whatever explanations are deemed necessary for someone to handle the case.
And it's more than that, Cosmin, because of course all the teams are available during the proceedings, but also before. I'm sure that, Maria, you've got numerous phone calls to check an arbitration clause when it is about the drafting of the contract. So it's before and pending the case.
And after.
And after.
And after, if there are questions on enforcement. And I have to say, of course, we will never provide legal advice. So we only can clarify how the rules and the procedures operate. I cannot, as the independent institution, provide legal advice to to the party that acts without a lawyer. But I can clarify the procedures, and that is absolutely fine, and it is actually what I do for most of the day. So during the day when I'm at the office, I'm usually on the phone or speaking to people or answering emails, and most of the job that I actually do, such as reviewing awards, is done at home late at night.
Yeah. This is essential, and I'm sure that those who are not aware about this reality, because it is a reality, and I can confirm that the Secretariat is always very open to clarify any issue the parties or the Council may have. Now they are aware about it. Sticking for a little while with this delicate issue of the costs. It is delicate because parties need to have the costs that are to be advanced for an arbitration. If I have heard in my entire life complaints about ICC, the only one I believe I ever heard is that sometimes it costs too much. So this is the only thing a Romanian may complain about ICC. The paradox is the following, and my question is inspired by your last answer. The parties, and I have concrete cases, complained about the costs that they are supposed to advance for an ICC case when they face the case, not when they enter into the arbitration agreement. The question, which is kind of absurd. I mean, if you agree upon a certain arbitration, you should be aware that for an anticipated dispute of 100,000 or 1 million or 500 million, the costs are around within those limits established. The question is, can we help somehow the parties be aware also about the costs when they enter into arbitration agreements? And as a final explanation, part of my question, I have discovered as a practitioner in too many cases that the parties entering upon a valid arbitration agreement here in Romania, some of them of course, don't really know what they're doing. They understand that they go to arbitration and not to a court. But what arbitration, what rules, what language, what place of arbitration, which costs, they discover it sometimes when it is, according to their budget, too expensive or too much or not what they really consider. Okay. It is, in my view, a matter of lack of sufficient information. And the question becomes, from your huge experience, how can we help those parties not to end up in that situation, which is, again, kind of absurd?
I think in terms of helping the parties, when you enter into a contract with an arbitration agreement, it's difficult to predict what the amount in dispute in. Well, the first point is that you hope that you will never ever have arbitration as a businessman. Or litigation.
Yes and no. I mean, it can, depending on the value of the project, certainly. You can actually foresee that you are going to have a dispute in a range between, if the contract is 3 million, you cannot have a 100 million dispute.
But then lost profits difficult. Yes. It's sometimes difficult. Yeah. So the only thing that we can do, is to put the scales on our website and in this booklet, which is much more predictable than, for instance, institutions which use hourly rates as the system of remuneration. Yes. So I think to the extent that we actually give the numbers for our costs, it cannot be more transparent than that. But I think that, and also the ICC court has now become even more strict in controlling time and costs. When arbitrators are delayed, their fees will be cut, so as to make sure that the parties get what they pay for. And if the arbitrators are delayed, they will not be paid in the same manner as the arbitrators who are efficient.
But it's a delicate question because you're talking about the arbitration agreement, and very often the contract is not negotiated by the legal team. We might be aware of what is arbitration and what are the different resolution tools they have, but it's often negotiated by the commercial team. And that's why we call usually the resolution clause at the midnight clause. So it's probably about maybe an internal education within the company to make the negotiators aware of what actually this clause means. And certainly there is an interesting work to do on information and sharing information about what is arbitration and what is it about. So
the advice that I definitely give to the business community is to always consult dispute resolution clause with lawyers and with specific teams in charge of. So, but if it's not possible, consult it with the ICC, because the parties should know what they agree to. Definitely, I agree with you.
I think this is the most concise advice that can be provided. If a lawyer cannot help you, or you don't have a lawyer's help, in what you can always contact ICC directly, search the website, and know exactly which are predictable costs for that arbitration. And this goes for any other arbitration you may agree upon. It's not a particular advice. There are voices saying or people addressing the issue, what is the best arbitration? As if I ask you, what is the best food? Answer it now. Depends on your problem,
what you like,
on the dispute, on everything. You cannot reply the answer, what is the best arbitration? And also the idea of, which I'm sure that is not as known as it should be, at least within the Romanian legal community. The idea that ICC is expensive represents, if a yes-no question, is false, because for a 200 and above euro million dispute, ICC is less expensive than a Romanian court. And I know what I'm saying, due to the scale and due to the legal texts which are not above a certain threshold diminishing. For a 200 million dispute, ICC is less expensive than going to Bucharest Tribunal. So you cannot state that it's expensive. But if you want to go to ICC for a $10,000 dispute, you better find some.
If you allow, I will quote a recent article by our common friend Jennifer Kirby, who described this problem very well. You cannot have arbitration cheap and good. If you want to have something very good, you have to pay a little bit of money. But you're right that it's in proportion to the complexity and to the duration, and to considering that in arbitration, different than in litigation, you only have one instance. It's very rare that you have to go through post-award proceedings. So in proportion to the duration of the proceedings, you will have to invest less money than, but you have to invest some money, in particular if the case is big.
You might wish to mention the cost studies that we had.
Absolutely.
Because we made a huge studies on our ICC cases, because we heard these comments quite often. So we say, are we really expensive? So we study a large number of cases, putting together all the figures. And you might want to comment.
No, go ahead.
And so we discovering with great surprise that in fact 86% of the cost were the legal cost. 12% are the arbitration fees, and 2% is the institutional fees. So the cost of ICC in itself is quite low in comparison with the external legal fees. And one of the great advantages as well of the ICC is the previsibility. That means when you start an arbitration, you know how much it's going to cost you, except for the legal fees. But at least on the ICC side, you know exactly. It's not based on the hour, it's just based on the amount. So and I think it's a great advantage for user, for company as well, to be able to get to their board and have an exact figures on what ICC will cost.
Yeah. To conclude on this issue, the arbitration hour, the project that you discovered today and that we are in actually now, was born because I have the strong belief that it is insufficient information, or the information concerning arbitration has not a sufficient spread within the Romanian legal community, and not only. I fight in this project for spreading the information, and for people that use arbitration, and for people who are not aware about arbitration's advantages, to discover them and to use them, and one day, hopefully, not to face, not even in one case, the unacceptable situation of a party choosing a concrete arbitration and then complaining due to its own ignorance about something in connection with that arbitration. ICC, and not only ICC, is so predictable. There are so many sources of information that enable a party to know exactly what to expect when entering upon the arbitration agreement. Unfortunately, it doesn't happen sufficiently as number of cases in Romania as opposed to other jurisdictions. Of course, I care most about Romania, which is my practicing jurisdiction. And I'm sure that your presence here, the messages that you pass, and the general attitude and behavior that ICC has is going to help also all those current users and future and potential users to have access to that information, which is going to make everybody happier and know exactly what they decide when.
But if I can just add that,
please.
Being Polish myself, I understand that there is a need to explain, and there are some cultural specificities that are in our region that we have to take into consideration. So in our team that is mostly composed of people from Central and Eastern Europe, we do feel that there is the need to communicate, but also to listen to people. But I think it cannot, arbitration is much newer here than it is in France, Switzerland, and Germany. Not so.
So we have a 60 years commercial arbitration dispute, but indeed what used to be until 1989 is completely different to international arbitration.
Yes,
but I'm glad to have the confirmation from you that it's not a Romanian problem, but rather...
It's not a problem, it's a challenge.
And this is the final question upon this issue. Is it correct to state that this is a matter of maturity of the market? As time goes by and people get more and more used to arbitration, these kind of problems disappear?
I think so. It's an evaluation of the... people have to get used to the tools, yes. I don't know if maturity, and I think that, arbitration is evolving all over the world. The stage that we've reached in, in France and in England and the US, the practices keep evolving all the time. So I'm not sure if the idea from Central and Eastern Europe is just to be like French. I think the idea is just to get used to the tools, modern tools, and adapt them to the local market. It cannot be the same everywhere.
If Romania is going to be like French in 20 years, we are behind reality once again. So indeed, we need to...
But I
remain updated with the reality.
I take this opportunity to say that we came for the first time, but we will be happy to come back. And then I take this opportunity to make an open call for invitation. So if one of the people who listen to us today wants us to come to visit them and to make a presentation, an explanation, a training, or whatever, we'll be more than happy to answer to the invitation. So it's an open call.
Exactly. And more concretely, everybody watching us, if you want to know anything about ICC arbitration or alternative dispute resolution under ICC, you can always send an email or make a phone call, and someone will immediately reply and clarify that information. And now we can move forward. An essential event that took place early this year was the entering into force of the new ICC arbitration rules, the 2017 version. Let's pinpoint what's new.
Yes, there are several new things. During the conference, we concentrated on the first aspect of the new rules that entered into force on 1st of March, the expedited procedure for small claims. The second, and we may talk about it later, the second change goes in the direction of speediness and efficiency. We reduced a time limit in the first stage of arbitration for establishing terms of reference from 2 months to 1 month. This is a document that is to put the frames for the tribunal's mission, work, and the parties' claims. And we considered that 2 months it was too much, and so that was shortened. There was also a change in order to make the court decisions more transparent. In Article 11, the clarification was deleted, saying that the court's decision on the with respect to the reasons, there was a provision saying that the reasons for the court's decision on the confirmation and appointments and challenges shall not be provided. Now this has been deleted, thus opening the floor for users who want to have reasons to the court's decisions on, in particular, challenges, that if they wanted prior to the decision, they may ask for the reasons, and the reasons shall be provided. There were also some other cosmetic changes, but nothing of big importance for the users.
Okay, let's stay for a while with I think the most important new part of the rules, expedited procedures. Here in Romania, so I'm not referring to the ICC perspective, but the needs required by the Romanian market. This is a dream for many parties. Everybody complains about the lack of a really efficient and speed procedure to clarify and aimed, of course, to provide an executory title, because there are all kinds of procedures, but they lack the executoriality force. And this comes in trend with what happens with other international courts, arbitration courts, and not only, to provide what was missing. Now, can you please explain a little bit the rules and their incidence? And the next question, but I prefer to address it right now, is what kind of immediate or soon impact can you foresee? Because the question becomes, when can people watching us really expect to use them? Can they file the claim tomorrow for their problem that occurred for 2 years in Romania and they were unable to find a way to solve the problem fast in a speedy manner?
First, in terms of the why the rules were put in place right now, the discussion at the ICC about the need to put in a specific set of rules for small claims has been there for a while already.
Yeah.
It was debated several times. It has now been put in the 2017 version of the rules as a response to clear signal from the users and based on our observance of the practice. The practice that we see is that in cases up to $2 million, it's approximately 30% of ICC cases.
30.
About 30%.
3-0.
And so 3-0. And so we also see, and I see many of these cases in Central and Eastern Europe in my team. The other practical remark is that in most of these small cases, the parties don't wish to have a hearing. And many of these cases were already conducted based on documents only. And in many of these cases, parties were complaining as well, oh, do we really need terms of reference? And we were saying, yes, it's a mandatory requirement under the rules. So because of the voices from the users, and you have to, you know certainly, Cosmin, but the works on the new rules are always done by the ICC Commission, which is a legislative body of the ICC. Yeah. And corporate users, in-house counsel, are very largely involved in the works of the Commission. And so it's not just lawyers drafting from law firms, but also in-house. So it's a common effort. And so these rules were created to reflect the practice. And for disputes where the amount in dispute is up to $2 million, but if the contract was entered into after 1st of March, they will apply. What it means, in answer to your question, if a contract was entered into 2 years ago and the case is filed today, the expedited provisions, if the amount is below 2 million, will not automatically apply. However, the parties could agree to opt in, but it doesn't why it doesn't automatically apply? Because we didn't want to surprise the parties. You said that the parties have to know when they enter into agreement to arbitrate what they agree to. If the party concluded agreement to arbitrate 2 years ago, it was not this version of the rules. So we would have surprised the party with the expedited provisions. So it only applies to contracts entered into after 1st of March. So that is the scope of application. And so I've mentioned that the first point is that in expedited procedure, the terms of reference step was deleted. It's no longer mandatory. It is only mandatory to hold a procedure meeting, case management conference, because it's important for everybody in arbitration to get together either in person or by telephone or by video to discuss how arbitration should look like. Arbitration is supposed to be flexible, and arbitrators and the parties should always sit together and adapt the procedure in the case to the specific needs of the given case. And there are many in the new rules, in particular in Appendix 6, that deals especially with expedited rules. There are specific provisions that provide for specific powers of arbitral tribunal that acts under expedited provisions. The idea is to give to spell out in the rules the tribunal's power to control the proceedings and to control the evidentiary proceedings, to avoid the situation that in a case for $1 million, you have each party has 10 witnesses, 2 experts, and that you have a 10-day hearing, which may not be proportionate for a little case for payment of 1 invoice. And so under expedited provisions, the rules recognize, and so the parties agree to the fact that the arbitral tribunal can limit the evidence, the witnesses to be cross-examined. So the idea is for the tribunal to be in control. Now, obviously, if the party's right to be heard and due process will be respected, that is key, but the idea was not to reproduce in smaller cases the mechanisms that are applied in larger cases, which is unfortunately sometimes done by simple automatic approach, that if it's arbitration, it has to be complicated. It doesn't have to be so.
For sure. A few follow-up questions in order to clarify potential issues that may be of crucial interest for our viewers. As far as costs are concerned, which is the difference between an expedited procedure and the normal arbitration under ICC?
Well, the idea is for the same reason, not to repeat what is done for larger case. So so it's shorter with less compulsory steps. So and then the fees of the arbitration are reduced by 20%, and actually it's less costly.
20% less the fees of the
arbitrators. Yeah.
In expedited procedures. Sole arbitrator or 3 arbitrators, or depending on the will of the parties, which is the provision of the rules?
The rules say that it's in principle 1 arbitrator, and the rules also say that even if the parties agreed in the arbitration clause to 3 arbitrators, the parties agreed that under expedited provisions it will be 1 arbitrator. Now, obviously, we recognize for now we haven't had any case yet, and because
it's too soon.
It's too soon.
Yeah.
The rules say the court may appoint 1 arbitrator even if the clause provides for 3, which gives the court flexibility. If there are compelling reasons for remaining with 3 arbitrators, obviously the court will do it. The same for expedited provisions, even if the amount in dispute is below 2 million. But it's very complex. There are very sensitive issues in the case. The court may decide that the case is run under regular procedure. So under the rules, we leave ourselves flexibility, which is always needed also, or maybe especially on the institution side.
It's a touchy point. It's a touchy point, and we understand that the choice of the arbitrator is something key for the parties, and they want to keep in control with that. So that's true that the rule are saying that it's 1 arbitrator for cost reasons, because it makes the one more logic. But of course, if the parties agree and really want 3 arbitrators, they could express these wishes, and the court will listen to it, of course.
That was my question. The default rule is 1 arbitrator for expedited procedure for obviously cost reasons. If stubborn parties agree upon 3 arbitrators for expedited procedures, the court will allow them to pay more but fulfill their wish to have 3 arbitrators.
It will be always decided on a case-by-case basis. I cannot predict.
As a matter of principle.
But I think the court will seriously consider the parties' arguments. Definitely.
Okay.
We are lawyers. We always have to say it depends.
Yes, of course. Now, as far as the duration is concerned, the question from a Romanian entrepreneur who wants to know exactly what happens is, can you guarantee me a certain duration of the expedite procedure? I was their voice. The answer would be?
Well, we haven't had any now.
No, but according to the rules.
But according to the rules, from the filing of the request to the transmission of the file to the tribunal, I think we can expect up to 2 months maximum. Then 1 month for terms of reference, that is 3. And then from that stage, case management conference, so initial meeting to final award, it's 6 months. So in total, it will be less than 9 months.
Less than 9 months, which is magnificent for.
And frankly speaking, even with terms of reference in my team, there are small cases that are run in less than a year. So it happens, yes. Without a hearing. Sometimes without a hearing, but with a proactive tribunal sending a list of neutrally phrased questions to the parties. So there are other means of efficient and cost-efficient resolution of the dispute that can be used in arbitration to avoid costly hearing. We mentioned cost a lot during this meeting. It's an important issue for the users. And you know very well that in arbitration, hearing costs is one of the largest part of the costs in total, legal costs in particular.
Sure. Now, another issue, you mentioned it earlier, that the duration of signing the terms of reference has been shortened. Mm-hmm. What happens, and I'm sure it will happen one day soon in practice, when for various reasons the parties agree upon, claimant and respondent, 3 months, not 2 months, necessary duration to sign terms of reference. Are the parties free to delay their own proceedings if they agree upon a lengthy?
The time limits in the rules, we will have to extend it, but of course upon clear agreement of the parties, the court will extend the time limit for the terms of reference.
So what is essential for our viewers and for the potential parties is to understand that the rules are never aimed, not even in one point, to act against the will of the parties.
Absolutely.
The golden rule is the will of the parties, always.
No, but I think it's important to have these deadlines in the rules to sort of discipline everybody. I can see definitely if there is a deadline in the rules, if you have to ask the court for an extension, you have to, you're showing that, you're delayed. In your head, that triggers something. Yes, so I think that there are some deadlines in the rules that has a good impact on the cost-efficient.
And on the other hand, I think that in the gross majority of the cases, whenever the claimant and the respondent agree upon something, there is a legitimate reason behind and not any unusual or an unhappy cause.
Unless it goes against the main principles of the ICC rules. For instance, the parties couldn't agree to exclude the court's power to confirm arbitrators or to scrutinize awards. Yeah. But if it doesn't go against the key mandatory elements of ICC arbitration, of course, parties' agreement is always key element, yeah.
So, what you described and the answers that you provide are clear arguments that these expedited rules should be a successful newcomer in the rules. Of course, we need to wait a little bit so that new agreements are going to lead to cases, but I don't know if the parallel is in any way relevant. The question is, the emergency arbitrator has been enacted as a possibility 5 years ago, I believe, in 2012, if I'm not wrong.
Yes.
Yeah. And as far as I know, there are very few cases of emergency arbitrator.
No, there are quite a lot.
There are a lot.
More and more. I think we have like every weeks or every 2 weeks we have a case.
We've definitely seen
it's really growing.
But in the first years, there was a very limited impact.
You know why?
It takes time.
Because it applies just like these rules.
The same.
Only to the contracts that were entered after 1st of January.
So we are getting close to my parallel. A new let's call it institution, a new reality within the rules, takes a necessary time of, from this example, 2 or 3 years until newly entered arbitration agreement lead to disputes and make them practically incident for a certain case. So from this perspective, we should not expect a revolution of expedite procedure claims in 2017. It would be impossible.
No, but we should definitely use this time to explain to the users how it works, and to make sure that those who enter into contracts today and this year will understand that they agree also to the new provisions. So that is the goal of the
and there is also, please go ahead.
What is already very interesting is that the rules are aimed for claims under 2 million. But we already heard some users saying that they wish to use the rules, the expedited rules, for bigger amounts. Because for instance, sometimes you have a big case, but the issues are very simple. So you do not need all the
payment of an invoice should be simple, irrespective of its value.
So
if we discuss only about why an invoice was not paid and not technical reasons behind not paying.
Absolutely. So it will be very interesting in 2 years' time, maybe to draw some conclusions on how these rules will be used. So it's impossible to predict now, but
the small threshold is a matter that should be considered from jurisdiction to jurisdiction. Here in Romania, in our civil procedure code, we have small claims of under 10,000 or 15,000 euros. That is considered by the law before ordinary courts to be small. In London, 15,000 euros is the cost of spending a weekend in a nice hotel. So
well, I think
completely different.
ICC is an international institution.
Yes.
We apply, our rules are applied all over the world. And we just looked at the practice, and also in Central and Eastern Europe. We are not saying that it's not rules for small claims. We don't say that 2 million is small. I mean, to me, it's a lot of money, personally.
To me also.
to me also.
But the idea is that these claims up to 2 million, looking at our practice, simply didn't require the stage of terms of reference. And in these cases up to 2 million, the parties didn't want a hearing. So if we can shorten and simplify these proceedings, why not? It doesn't mean that they are simple at all. It doesn't mean that we will not need good arbitrators for them. We will need very good arbitrators.
Especially if they are sole arbitrators.
Exactly.
Absolutely.
Yeah. So it doesn't mean that it is simplified, it's just shortened and the procedure is slightly, but it's the key elements of ICC arbitration, including scrutiny of award, is maintained.
Yeah, fully agree. Now one confirmation I would like from you, one final question, and then we move to another final topic as we are getting close to the end of our roundtable discussion broadcasted today. The parties, or some of those who are watching us may say now, what a pity. I have the exact dispute that could be governed by these expedited rules, but my contract was entered at point in 2013. And I want to let them know, and you to confirm, that nothing prevents you to go to ICC now, agree upon with the other party, and use the expedited rules exactly now, today or tomorrow, because it is possible to opt in the rules, irrespective of the date of the contract, and irrespective of the fact that maybe they haven't had at all an arbitration agreement 5 years ago or 3 years ago. Am I right?
Yes,
absolutely. Yeah, it's you exactly summarize the situation. You can opt in and you can opt out. That's mean
opt out if you enter upon a contract today and you don't want the rules.
You can opt out. You have to agree. The parties have to agree, but you can opt out. Or on the contrary, you can opt in if or your case is bigger than 2 million, or your contract has been signed before the 1st of March of 2007. So it's very flexible.
Yeah, but you can do it already when the arbitration is it has been filed. So in your case, when your businessman filed a request for arbitration with the ICC, based on contract which is from 2 years ago, but he wants to try to have expedited provisions. He just, in the request, he writes, but I would like another. And just we invite respondents' comments. So we don't need the opting in, doesn't require an agreement in front of the notary public. It can be done by simple exchange of emails.
Sure. And final question on the interesting and the challenging topic of expedited procedure. Let's assume that the claim is under the threshold 1 million or even less, but it is the most complicated case. It requires not one, but 10 technical expertise. It's, you know, discovery of a new chemical substance which exploited during the unfolding of the contract. What happens in a case like this?
Well, I wish I see, but if it is, I think is here again a case-by-case situation.
Okay.
I'm sure that in this kind of situation, or the party will agree to opt out and to have the regular rules because they want to have all the steps because it's too complex and they will have to have 3 arbitrators.
Yes,
or
but the respondent may say, no, I want to stay in because it feels that it is impossible for the claimant to administer all the necessary evidence, and then the question is,
the court
the
court might probably decide to impose 3 arbitrators in that case.
There's a question of application in your case that is so complicated. Yes. If a claimant feels or respondent that the case is particularly complex, but the parties do not agree to opt out,
yes,
one party can request that the court decide that the expedited rules should not apply in this case. So that is the first question, whether expedited rules. And then Laetitia also referred to the number of arbitrators. We already mentioned that in specific cases, even if it's expedited, the court may recognize the need to have 3 arbitrators. So there's nothing is set in stone.
No, your first answer was addressing the
application of the rules.
Yes, because the idea was expedited rules to be in concreto, in that particular case, incompatible with the complexity of the case. Okay. The value is low, but the complexity is huge. And then the answer is very clear. There are specific rules, and the court decides, if appropriate, that the rules are not to apply, even if formally the conditions were fulfilled.
We should stress that under expedited rules, it doesn't mean that there are no evidentiary proceedings.
Sure.
And that obviously in expedited provisions, the tribunal has full discretion, and an intelligent tribunal will not refuse the party's right to be heard if there are compelling reasons. So it doesn't mean that it's just...
Anyway, really necessary evidence will not be refused in any proceeding by an intelligent and experienced arbitrator, because it is essential in order to establish the situation and find out the truth and issue an award.
And that is why we need, in terms of disputes from Central and Eastern Europe, we are trying to appoint more and more arbitrators from Central and Eastern Europe, because in order to decide these issues, what is the need, what is the complexity, you really need to understand the local flavor and the cultural specificities.
Mm-hmm. And now one final topic. I think that very likely more than half of the people watching us now are young and very young, and interested in arbitration. And the question would be, what does ICC offers for all those young viewers and practitioners and future practitioners interested in arbitration in Romania? Laetitia?
Excellent question. It's happened that you are the representative of ICC
by accident.
By accident.
The question has nothing to do.
In addition to being young.
No, but
that's obvious for everybody.
No, I'm very glad that you accepted this role and that we have a Romanian representative. The YAF is the Young Arbitrator Forum, so it's a young association linked to the ICC court. It's free. It's very easy to register. I think it's www.iccyaf.org probably. You just have to put your name and your email, and you will receive all the invitations and all the news. And I really invite every people under 40, let's say, even if we flexible on the age, to join. It's really easy, and it's a way to keep contact with us and to stay informed. I don't know if you have already set up a program for Romania or for the region.
I haven't set up a program, but I think we can publicly announce that at least one early event is going to be organized by YAF in Bucharest or in Romania in the following years. And I hope there are going to be more than one each year, because there is a huge interest, and I know it directly. I have been contacted, I know from peers that there is this kind of interest. But on the other hand, this free YAF membership provides access to a huge volume of information, not only concerning future events organized in Romania, but concerning all the other events organized by IAF. And now if I can indicate some of the projects that IAF has worldwide, it was discussed two weeks ago in New York when the biannual conference took place. A blog dedicated to young users who are going to provide articles represents a plan that hopefully is going to be implemented soon, and they are going to have also access to this kind of instrument to share their views upon arbitration issues. And there are many more other aspects. So the first step for everybody interested in ICC and in ICC's help for your career would be to join the Young Arbitration Forum, which is the dedicated body for young practitioners. And I think that would be it. It was very, very, very interesting. I'm happy that I caught the opportunity and had the chance to send the message to everybody interested here in Romania. Now, because you'll not be able to refuse me, I hope you promise that whenever you visit Bucharest next,
of course,
we can have another discussion, of course, upon different topics.
With pleasure.
Thank you once again.
Much.
And I'm going to use other opportunities to inform in an appropriate manner everybody interested in ICC.
Thank you very much.
Cu aceasta se încheie emisiunea noastră de astăzi. Cu adevărat intrăm în vacanța de vară și ne revedem în septembrie. Rămâneți cu bine! When I have had the first two